Chapter 4, Protecting Individual Rights. Civil Liberties, Protecting Individual Rights. So as these screens with this, Apple IIe, or what is that, an NEC from the 80s. Everybody has on the 80s clothes. They're searching somebody's house, burning an American flag. Exercising their right of assembly. Getting arrested. And then we land on this photo, which many students have explained to me is seriously photoshopped. But just note that this gentleman is African American, and that his job is to protect the liberties of people who are obviously in the Ku Klux Klan. Notice the hoods. Notice the odd cross on the flag and on their uniforms. And just remember that in America, we often protect people's rights to be ugly and to do things that are unpleasant. Civil liberties is not a protection of things that we always like. Civil liberties is a protection of the right to say and do things, and protection from the government making things criminal just because they don't like it. This is really, really old, but if you just compare, and this is according to Freedom House, which is an independent organization, and they basically track civil liberties. And this was definitely done a while ago. But the United States is still among the most free nations. And I think I mentioned in a earlier lecture that it is probably those freedoms, it is what we have come to expect, that has made our response to the coronavirus epidemic so difficult, because when you start requiring us to do things, then we get upset. And even when you require us to do things, when we feel like rights are being infringed upon, then we're going to exercise other rights. So it really today, and I'm doing this on September 22nd, 2020, the concept of our ability to do things is knocking heads with our need to do things. But we in the United States have a lot of rights. So let's get some framework. Remember, I told you about the importance of vocabulary. So when we say the word civil liberties, what we mean are specific individual rights. And those are protected by the Constitution of the United States against infringement, and that means coming in and giving you a fine or taking you to jail or telling you that you can't do it. And the government has restrictions that are listed in our Bill of Rights, and they explain the rights that government, the things that government can't do. So I don't think that I spent a lot of time in chapter 3 talking about the case of Barron versus Baltimore. Barron versus Baltimore was a case where Mr. Barron sued the city of Baltimore because, and he was a wharf owner, and he basically had a place where people would come and dock their boats in the bay in Baltimore. And the city of Baltimore was doing some work, and they diverted the water from its natural course, and it made the water too shallow for people to actually come into the area where Mr. Barron was operating his business. So he said, you know what? The government is actually taking my property. You're taking my livelihood and my money through making my business, and you're not compensating me for that. You owe me some money. Now, that whole concept that the government can't take your property without a just and right compensation comes from the Fifth Amendment. It's called eminent domain. So there are times when the government needs your property. They need to put in a highway. They need to put in a government building. And as long as they are going to be using it for public good, they can actually have your property. But there's one restriction. And that restriction is they can't just take it without paying you money. So Mr. Barron sued on the concept of Fifth Amendment, eminent domain, and the case got all the way to the Supreme Court by 1833. When the Supreme Court got this case, they looked at it and said, well, there's only one problem. We're not saying that the city of Baltimore, a governmental entity, didn't take your property. We're not saying that they did. But the Bill of Rights, when it was originally written, was only intended to restrict the federal government. And it only applies to the federal government. So, therefore, we can't help you because this limitation is not for a citizen's cause of action against a local or state government. Fifth Amendment only applies to the federal government. So that was the prevailing wisdom. Remember that this case was heard in 1833, and that was the way that they dealt. When I say they, I mean everybody in the United States was bound by the decision that was made by the Supreme Court. And I guess I have to stop here and explain a concept to you. And that concept is English common law. So this is one of the things that the founders brought over and continued to apply from England. And it was this concept that there are some things that are not passed by your legislative body. In England, that would have been Parliament. In the United States, that's our Congress. It doesn't go through the legislative process. It is either a custom or it is the decision that is made by the court, and the latter is most important for our discussion right now. When our courts make decisions in the United States, we treat their decisions like law, just like it went through the legislative process, and they remain the law until they are overturned, either through another court case or through the passage of an amendment or through the passage of a law. So then we have to take a couple of steps back and remember, so this was Barron versus Baltimore, this was the common law. And remember in 1857, the Dred Scott case. The Dred Scott case said that African Americans, whether they were free or not, were not citizens of the United States. And because they were not citizens of the United States, they could not use the court system to address their grievances. So we had a civil war in the United States. The Civil War was won by the Union. One of the things that they did, that Congress did, was they passed or passed the 13th Amendment, and the 13th Amendment abolished slavery, and it was ratified through the process by 3/4 of the states that were in the Union. And then as the states that had seceded and had been on the losing end of the Civil War started to come back, started to draft their constitutions, they all renounced slavery as well. But the 14th Amendment, passed a few years later by 2/3 of Congress, was ratified by 3/4 of all the states that were in the Union and the states that had seceded. And one of the things that they did in the United States Congress was said, if you want to be readmitted to the Union, you will ratify the 14th Amendment. And as a result, all of the states that had seceded ratified the 14th Amendment. 14th Amendment was passed or ratified in 1868, and most states were readmitted to the Union in 1869. In the case of Texas, 1870. So what does the 14th Amendment say? We're just going to go to the next slide and then we'll come back. What does the 14th Amendment say? Well, the 14th Amendment says that all persons that are born or naturalized, meaning that they were granted citizenship through a process in the United States, and subject to the jurisdiction thereof, are citizens of the United States and the state wherein they reside. Let's break that down a little bit. Number one, first thing that they did was they overrode the Dred Scott case, because they said if you were born or naturalized in the United States, you're a citizen. You're a citizen. So right there, they are overriding the Dred Scott case that said that if you are of African descent, then you're not a citizen. So start there. And then they say, not only are you a citizen of the United States, you're a citizen of the state where you reside. Now, if you go through the Bill of Rights, 1 through 10, Amendments 1 through 10, you will not see the word state except for in the 10th Amendment, where it's saying everything that hasn't been granted to the United States is a state right. This is the first amendment that directly applied to states and said the word state. Now, with that in mind, let's read the rest of it. No state shall make or enforce any law which abridges the privileges or immunities of citizens of the United States. And who are citizens of the United States? All persons born or naturalized in the United States. Nor shall any state deprive any person of life, liberty, or property. We're back to John Locke's life, liberty, or property without due process of law. The government has to follow the steps. And theoretically, the way this reads, that's the United States government or a state government has to follow the steps, due process of law, before they take away any citizen's right to life, liberty, or property. Finally, it goes on to say that they also can't deny any person within its jurisdiction equal protection of the laws. So we have three major, well, really four major provisions of the 14th Amendment. One of them is the citizenship provision. No, if you're born or naturalized in the United States, you're a citizen of the United States. The second is the privileges and immunities. You get privileges and immunities as a citizen, and the United States government can't take those away, but neither can a state government. The third is the due process clause. You cannot, as a citizen of the United States, have your life, liberty, or property taken away without due process of the law. That is called the due process clause. So that's number 3. Number 4 is the equal protection clause. You cannot have your life, liberty, or property taken away, and you cannot be denied equal protection of the law. The 14th Amendment is huge. It was a game changer because it was readjusting how the government was going to deal with citizens and how it was going to deal with states, theoretically. So notice here at the bottom that it says the Supreme Court engaged in selective incorporation. So let's talk about the concept of selective incorporation. Selective sounds like picking and choosing. And that is definitely what the Supreme Court engaged in. They did not say automatically all the parts of the Bill of Rights that have to do with due process and all the parts of the Bill of Rights that have to do with laws are now applicable to the states. What they said was, in certain circumstances, we are going to apply the Bill of Rights to states selectively. So what is the criteria that they used to select which parts of the Bill of Rights would apply to states? Literally, what they were saying they could do is tell a state that their state law violated the Constitution. This is exactly what had been denied to Mr. Barron in Barron versus Baltimore, because they said Constitution of the United States and the Bill of Rights doesn't apply to individuals when their cause of action is against a state government or a local government. Here, they're saying in certain instances, it does apply. It does apply. So, in essence, they were setting up more power for the federal government. So applying due process to rights that are listed in the Bill of Rights is called the Incorporation Doctrine. The Incorporation Doctrine allows the court to apply Bill of Rights to states. But again, what the court decided that they were going to do was selectively do that on a case-by-case basis until they decided that it was the proper thing to do. So it really, at the end of the 19th century, there was a case that came down where the Supreme Court told a state that had taken somebody's property and hadn't given them any compensation that their particular law was a violation of the Fifth Amendment, just like Mr. Barron's case had been. But they said it's a violation of the Fifth Amendment. We are applying the Fifth Amendment to your state law. Your state law is not going to work, and you need to give that person some compensation. So late in the 1800s, we saw use of the 14th Amendment. This dapper gentleman in the pinstripe suit is Benjamin Gitlow. Mr. Gitlow was the executive secretary of the Socialist Party in New York City to be exact. And Mr. Gitlow was a socialist, meaning that he thought that purely government should run the economy and have control of the economy, that no person or entity should have more money than any other. In a purely socialist economy, you have redistribution of wealth, meaning that everybody sends their money, any money that they make, it goes to the government, and the government decides how to distribute it. Sometimes the government distributes goods, sometimes the government distributes services, and sometimes the government distributes cash, but they equalize it so that no individual person is getting more money than anyone else. So it doesn't matter what you do. It doesn't matter if you're a doctor. It doesn't matter if you are a ditch digger. It doesn't matter if you do not have the ability to work. Pretty much all those people in all those different categories make the same amount of money. That is not what we have in the United States. We have a capitalist society that allows people and industries to make as much money as possible. And while we do have some redistribution through taxes, we don't have a society that is purely and completely run by the government. So when Mr. Gitlow wrote his manifesto, he was urging workers in advocacy of a socialist society to overthrow the government, because that was the only way that we were going to be able to get, in his mind, to a socialist society. You were going to have to overthrow the government. So that's what he was urging workers to do. When the city of New York got a copy of this manifesto, Mr. Gitlow was arrested and charged with a violation of New York law that made it illegal to advocate overthrow of the government. I mean, it was textbook. Here he was advocating overthrow of the government. The state law said you couldn't do that. He was arrested. Mr. Gitlow appeals his case, his criminal case, and loses on the appellate level and loses at the New York Supreme Court. Then his attorneys decided to appeal the case to the Supreme Court of the United States. And basically what they argued was that the First Amendment freedom of speech and of press, because this was printed down, were being violated by the state of New York. And that when the 14th Amendment said that you cannot deprive somebody of life, liberty, or property without due process of law, and when the First Amendment said that you have freedom of speech, the New York law was actually violating the First Amendment freedom of speech, and the 14th Amendment gave the court the right to tell New York, you can't do that. And the court in 1925, several years after the 14th Amendment was passed, agreed. This was actually the first case where the Supreme Court said, you know what, you are absolutely correct. We believe that the freedom of speech and of press are so fundamental. Put a pin in that word, fundamental. So fundamental that we cannot let a state take them away. So they wrote this wording. They ended up telling the state of New York that their law was a violation of the First Amendment freedom of speech, and that their law violated a fundamental right. Gitlow versus New York. So if we are talking about the progression of the concept of selective incorporation, we have to first go through the 14th Amendment, explain the 14th Amendment, explain that it applied to states, explain that it gave the federal government the right to look at state laws, and for the most part, do judicial review. Say that the state law was unconstitutional, which they did in 1925. Mr. Gitlow's conviction was overturned. New York was told that this law was unconstitutional, and all states were on alert that if their laws took away the freedom of speech and of press, that they could be overturned. 1931, a few years later, the Supreme Court heard the case of Neer versus Minnesota. Mr. Neer was not a very nice guy, and he had a newspaper, and their city was in the process of having elections. And so Mr. Neer started publishing in his newspaper, I shouldn't call it little, his newspaper, information about the people that were running for office. And he said that they were having conspiracies, and that they were part of Jewish gangs, and that they were stealing money, and that they were corrupt. And he was doing this in a series. So he would talk about one person one week, and then he would talk about another person the next week. Minnesota at the time had a law that said that if someone is saying bad things about government officials, the state of Minnesota gives authority to come and say, don't do it anymore. So they approached Mr. Neer and gave him what's called an injunction. Don't do it. And said, don't publish do not publish another article that is talking about these government officials. Of course, Mr. Neer published anyway, and he was arrested for a violation of the Minnesota law. Mr. Neer appealed his case to the Supreme Court just like Mr. Gitlow had. And the Supreme Court there solidified what they had said, what they'd said in the Gitlow case, but also said, your state law violates the First Amendment's freedom of the press. We have already said that this is a fundamental right, and we will be looking at cases from now on to look to see if they violate a fundamental right. We argue that this one does, that freedom of speech, freedom of press, we're going to already go ahead and say these are fundamental. And if we think it's fundamental, you cannot take away that right. Minnesota, your law is unconstitutional. And again, they overturned Mr. Neer's conviction. So let's really solidify this concept, the concept of selective incorporation. What we get is an examination of what the court at the time believed to be fundamental. About 6 years after the Neer versus Minnesota case made it to the Supreme Court, we had the case of Palco versus Connecticut. Now I have to go back and look at why the state of Connecticut was so angry at Mr. Palco. And basically, what I found out was that Mr. Palco had been caught or been basically involved in a chase after being observed in an armed robbery. And Mr. Palco turned around and started shooting. And in this chase and in his shooting, he actually injured one police officer and killed another. So they were upset with Mr. Palco. And so he was arrested and charged with first-degree murder in Connecticut. So Mr. Palco demanded a jury trial, which was allowed under Connecticut law. And the jury, once they heard all of the facts, they saw that the government had charged him with first-degree murder and that they were actually seeking the death penalty, but they didn't give him the death penalty. In fact, they charged him with, he was convicted of second-degree murder. The state of Connecticut, the district attorneys or the state attorneys were very, very upset. So he gets this second-degree murder conviction and no death penalty. So they appealed the case. The appellate court said, yep, there were some mistakes made and this is not right. We're going to send this case back down to the lower court and y'all can try Mr. Palco again. Now, what do we know? When you try somebody twice in the same court for the same thing, that's called double jeopardy. It is one of the hugest guarantees of the Fifth Amendment to the United States Constitution. And we know instinctively, it's one of those things that we know from watching television, from going to school. We know that you can't try somebody twice for the same thing. But in 1935, 34, whenever this happened, that had not been incorporated. And so Connecticut did not have a prohibition against double jeopardy. Mr. Palco thought that it was high time that they did. So his attorneys appealed his case. And it finally made it to the Supreme Court of the United States. They accepted the case, and they decided in 1937 that double jeopardy was not fundamental. So freedom of speech was fundamental, freedom of the press was fundamental, but double jeopardy is not fundamental, and they decided that they were not going to incorporate double jeopardy. Mr. Palco was tried again. The second time he got the death penalty. And the Supreme Court said, sorry, Mr. Palco, we can't help you. And he was eventually actually put to death. They confirmed his conviction, did not incorporate the double jeopardy clause of the Fifth Amendment, and Mr. Palco was put to death. It wasn't until 1960 that the Supreme Court, a completely different Supreme Court, or group of people, decided that, yeah, maybe double jeopardy is fundamental. That was way after Mr. Palco had already been put to death. It was way too late for him. I love this chart. This chart goes through the different amendments, the rights that are afforded, because just about every part of the Bill of Rights gives more than one right within it. And it tells the year and the case where that particular right was incorporated. So we've talked about Gitlow versus New York. That was 1925, the freedom of speech. Neer versus Minnesota, that was 1931. That was First Amendment, freedom of press. We're going to talk about a lot of these cases, not all of them, but we'll talk about a lot of these cases. This is an excellent thing to put on a note card as you are preparing to do a selective incorporation or essay or anything that addresses Bill of Rights, application of civil liberties. Because it goes through, it tells you freedom of religion was incorporated in the 1940 in the Cantwell versus Connecticut case. So the Fifth Amendment double jeopardy clause was finally incorporated not in 1960 but in 1969 with the Benton versus Maryland case. Now we're going to come back and revisit this chart when we start talking about the rights of criminal defendants, because you will notice that there's a little cluster of different things being incorporated. Some civil, some criminal, but there's a cluster of rights being incorporated. We had one court, that is the court where Earl Warren was the Chief Justice of the Supreme Court, where they were knocking them down. Cases were getting to the Supreme Court, and the Supreme Court were saying that's fundamental, that's fundamental, that's fundamental, that's fundamental. And that was Earl Warren, who was on the court from 1954 to 1969.